Chapter 13, Section 4, Federalism and the Supreme Court of the United States. Hello, everyone, and welcome back. So, we have learned in the past that federalism is the shared power between the federal and state governments. Now, we're going to look at a few cases that have impacted the power of the federal government and strengthened and sometimes provoked the state rights to the 10th Amendment. Our first case is Missouri versus Holland, a case involving migratory birds and the right to hunt them during a migration season. It began in December of 1916 when the United States and Great Britain entered into a treaty to protect a number of migratory birds in the U.S. and Canada. Congress passed the Migratory Bird Treaty Act in 1918 in order to facilitate enforcement of the treaty. When Ray P. Holland, a U.S. game warden, threatened to arrest citizens of Missouri for violating the act, the state of Missouri challenged the treaty. The state argued that the Constitution gave Congress no enumerated power to regulate migratory bird hunting, and thus the regulation of such hunting was the province of the states according to the 10th Amendment. The court upheld the exercise of the treaty power and found no violation of the 10th Amendment. The Supreme Court also reasoned that the national interest in protecting wildlife could be protected only by national action. The court further reasoned that the Supremacy Clause, which we talked about in Article 6 of the Constitution, renders treaties the supreme law of the land, a finding that trumps any state-level concern with regard to provisions of any treaty. The Supremacy Clause further implied that the treaty provisions were not subject to questioning by states under the process of judicial review. So did the courts get it right? Because if I'm not mistaken, state licensed hunters have to require safety and knowledge tests first. Should the federal government be telling us how to do that? Stay tuned for that one. It's time we look closer at the Constitution and a particular clause known as the Commerce Clause. It states that Congress has the power to, quote, regulate commerce with foreign nations and among several states and with the Indian tribes, unquote. Congress's use of this clause and the Supreme Court's interpretation of it have significantly defined the balance of power between the national government and the states. As a result, it has also helped to shape American life by valuing goods and services as well as people that cross state borders. Basically, if one crosses state lines in order to buy, sell, and or engage in transactions, whether legal or illegal, that is the definition of interstate commerce, and Congress therefore has the right to regulate that with any given state. Our next case involves racial discrimination, Congress, and of course the Commerce Clause. So Title II of the Civil Rights Act of 1964 forbid racial discrimination by places of public accommodation if their operations affected commerce. The Heart of Atlanta Motel in Atlanta, Georgia, refused to accept black Americans. The government sought to enjoin the motel from discriminating on the basis of race under the Title II due to the fact that the hotel sat off two major interstates which brought guests from around the country. The Supreme Court then had to decide if Congress, in passing Title II of the 1964 Civil Rights Act, exceeded its Commerce Clause powers by depriving places of public accommodation of the right to choose their own customers. Well, in a unanimous decision, the Supreme Court held that the government could enjoin the motel from discriminating on the basis of race under the Commerce Clause. Since the motel was positioned near Interstate 75 and 85 and received most of its business from outside of Georgia, this showed that it had had an impact on interstate commerce, which is all it was needed to justify Congress in exercising the Commerce Clause. We now need to shift onto the concept of selective exclusiveness. This is a legal doctrine that states that when the commerce at issue requires national uniform regulation, only Congress may regulate it. But if the commerce does not need exclusive national regulation and can be regulated locally, then the states have the right to regulate the interstate commerce. This, of course, is predicated on the justices of the court when they hear certain cases, such as Cooley versus Board of Wardens, which happened in Philadelphia, Pennsylvania. So there was a Pennsylvania law requiring all ships entering or leaving the port of Philadelphia to hire a local pilot. Ships that failed to do so were subject to a fine. Cooley was a ship owner who refused to hire a local pilot and also refused to pay the fine. He argued that the law violated the Commerce Clause, which gives Congress authority over interstate commerce and bars Congress from delegating that authority to the states. The court ruled that Cooley was in the wrong, since water navigation can change constantly by local conditions, and since locals would know those conditions, selective exclusiveness was enforced. Since this case, we now refer to selective exclusiveness as the Cooley Doctrine. Can you think of another way that this law could or would be applied? Our last case of this chapter involves Alfonso Lopez, a 12th grade high school student carrying a concealed weapon into his San Antonio, Texas high school. He was charged under Texas law with firearm possession on school premises. The next day, the state charges were dismissed after federal agents charged Lopez with violating a criminal statute, the Gun Free School Zones Act of 1990. Now remember, under the Fifth Amendment, you can't try a person twice for the same crime, which is why the state had to drop their charges and the federal government stepped in. The act forbids any individual knowingly to possess a firearm at a place that he or she knows is a school zone. Lawyers for the government argued that violence in school would lead to scared students, poor learning conditions, and eventually those students who were scared would become unproductive citizens. Subsequently, Lopez was found guilty following a bench trial and sentenced to 6 months imprisonment and 2 years supervised release. For those of you wondering, a bench trial has no jury, and everything that normally goes on in front of a jury is done instead with the judge. The question begs, is the 1990 Gun Free School Zones Act, forbidding individuals from knowingly carrying a gun in school zones, unconstitutional because it exceeds the power of Congress to legislate under the Commerce Clause? Well, if you answered yes, you're correct. The possession of a gun in a local school zone is not an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce. The law is a criminal statute that has nothing to do with commerce or any sort of economic activity. We will finish up briefly speaking on medical marijuana. Although your book touches on the use of medical marijuana, keep in mind that the age of this book and how much has changed over the past 15 years. The fact of the matter is that Mr. Norton and myself have explained that the federal government has classified marijuana as a class 1 drug. It's the same category as meth, heroin, and peyote. And regardless of what states do, it's still illegal. People who distribute the drug also face prosecution federally through the Interstate Commerce Clause because, as the justices stated, interstate commerce makes no distinction between legal and illegal products. In a slight glimmer of hope for the people who need the drug medically, now retired Justice Sandra Day O'Connor applauded people who took the risk to make themselves better with this tested product. And that is it, Mount Pleasant. Our test will be tomorrow. It will consist of 30 questions. You will have 3 attempts. Have a great day.